Hello, my name is Audrey,
And I'm Claire.
and we're sisters and teens interested in the Supreme Court. Today we'll be talking about the ongoing Supreme Court case, Federal Bureau of Investigation v. Fikre.
Let's dive in. This case begins with the no-fly list, which the U.S. government established after 9/11. If you're on the list, the government believes you pose a risk to national security and you're barred from commercial flights through U.S. airspace.
Moving to 2010, when U.S. citizen Eunice Fikre is detained by FBI agents on a business trip to Sudan. The agents inform Fikre that he's been placed on the no-fly list, then question him about his ties to a mosque he attends. The agents offer to take Fikre off the list in exchange for becoming an FBI informant, but Fikre refuses.
Fast forward to 2011. Fikre, now living in the United Arab Emirates, is abducted by the secret police, imprisoned, tortured, and interrogated again about his ties to the mosque. According to Fikre, one of his interrogators tells him that the FBI requested his attention and interrogation.
In 2013, Fikre sues the FBI for violating his right to due process, which states that the government must follow certain procedures before depriving a person of their rights. He contends that the government restricted his right to travel without reasonable grounds that he posed a danger to national security.
But while the lawsuit is pending, the FBI removes Fikre from the no-fly list. Since Fikre's right to travel is no longer restricted, the case is closed, right?
Not so fast. Let's take a look at the voluntary cessation doctrine, on which this case hinges. Let's say you have a case like this one, where a plaintiff sues the defendant for harmful conduct. The defendant says midway through the lawsuit, "Okay, I'll stop the behavior." Well, one worry is, how do we know the defendant won't resume their behavior once the lawsuit gets thrown out?
The voluntary cessation doctrine adds a guardrail. Under the doctrine, the defendant must make it absolutely clear the allegedly wrongful behavior could not reasonably be expected to recur. Applying this standard, the Ninth Circuit Court of Appeals rules that the FBI's case isn't closed.
In response, the FBI says it will not place Fikre on the no-fly list in the future based on its current information. Now, is that enough?
This is what the Supreme Court must consider. For this case to be moot, in other words, closed, is it sufficient for the FBI to say that it won't place Fikre on the list based on the information it has right now? Or does it face a heavier burden? For example, must it acknowledge that it originally erred in listing Fikre or change its policies so this doesn't happen again?
The FBI contends that the court need only consider whether it is reasonably likely that Fikre will be placed on the list again, citing the fact that Fikre hasn't been on the no-fly list for over 7 years. Also, placing Fikre back on the list would require a decision based on new information, meaning it wouldn't be a recurrence of the agency's past conduct.
The FBI also holds that whether this case is moot is separate from an admission of wrongdoing. Mootness only asks whether the challenged action is likely to reoccur and is separate from whether the defendant acted wrongfully in the past.
Meanwhile, Fikre points to two factors courts have traditionally considered to determine whether a case is moot. For one, is there a barrier, say a new policy, that prevents the defendant from repeating their conduct? Or has the defendant renounced their actions? Since the FBI has neither changed its procedures or renounced placing Fikre on its no-fly list in the first place, it doesn't meet either standard.
As to this case's high-stakes context, the FBI argues that ruling for Fikre could impede national security and lead to the compromise of highly sensitive information. Fikre, meanwhile, holds that there are legal tools to responsibly handle sensitive information and that national security cases should be held to the same standards.
The Supreme Court will hear oral arguments for the case on Monday, January 8th, with the decision expected by June. We hope you enjoyed the summary of Federal Bureau of Investigation v. Fikre. Thanks for watching.
And have a great rest of your day.